Nick Mosvick.
I got it the second time. Nick Mosvick. So Nick, you want to say hi to everybody, and we will jump in.
Hi, I'm Nick, and I am one of our senior fellows in constitutional content, and I've been doing the last month or so. We should probably just dive in because we don't have enough time.
We never, and this is a big one. So guys, please feel free as you hear things come up. Please put in the Q&A and the chat box any questions that you have, because we've been talking about it all weekend long, and we know we're just going to be able to scratch the surface. So let us know where you want to go. Real quick, we're going to do a quiz in the chat box. And don't worry if you don't know the answers, especially these last two. They're kind of hard. But let's start off with the first one. So in the chat box, answer for me, how many justices are on the Supreme Court as of right now? You can answer that. How many do we have in the Supreme Court? Take a guess. Put it in the chat box. See, Milo jumped in there. Very good, Milo. I'll keep going with the next question. Who nominates and confirms the justices? This is a two-part question, just to be quick. It's tricky. So, oh, good. I am loving Mercer Grimm. Very good. I know. So keep going. What are the three levels of the federal system? These questions get harder and harder as we go. But again, if you don't know the answer, it's okay. We're going to go over it in a minute. And then finally, what are the qualifications for the justices? So there are the kind of the four big ideas we're going to go through today: how a justice gets nominated, what's their actual job, and then how the court system works at three levels. And so real quick, we're going to go through the answers of these. So Nick, I'm going to try to support you with some beautiful images that I have gathered today. But how many justices are on the Supreme Court?
Everyone got that right in the chat. That's 9. And as we'll talk about, that is not set by anything other than Congress not changing anything for the last 151 years. For the second one, who nominates and confirms the justices?
Let's do it real quick. Sure. And we were just talking about this before we got started. Here, yes. This is the most recent photo of the Supreme Court. But give us a little, just real quickly, walk us through they are, and then I have the new nomination in the next slide. So Nick, you want to start with?
Yeah, and one thing I'll observe is that the way that they're set up is not by who's tallest, even though it appears that way. It's actually, these photos are taken to show you seniority, which is actually important because when we get to how conference works, how the court decides what cases they're going to take, how that voting system works, seniority really matters on the Supreme Court. So the Chief Justice, John Roberts, is sitting in the middle. He's seated. And then Justice Ginsburg is no longer with us. She would have been she actually was second most senior. Justice Thomas, who's to his left, has been on the court since 1991. So he's actually the most senior justice. The Chief Justice, of course, he has the most power, but the most senior members of the court are next to him. So Justice Alito was appointed in 2005, Justice Breyer in 1994. So that's how you see them. In the back, you see the junior justices, Justice Gorsuch and Justice Kavanaugh on the corners, who were nominated in 2017 and 2018, respectively. And then Justice Kagan and Justice Sotomayor, I think, 2010, 2009, respectively. So those
I couldn't remember who was first out of Kagan and Sotomayor.
Sotomayor was first, and Kagan was second.
And then Ruth Bader Ginsburg, Justice Ginsburg passed away, and the new nominating, and there's an image of her being sworn in with Amy Coney Barrett. So she would have been the newest member of the team.
Which means, by the way, she would have gone to the back, and then Justice Sotomayor would have been seated.
Huh, nice. Because, I thought it would be nice
again,
to get
seniority,
to know
though.
them. Yeah.
Because Alito is on the bottom for a reason, because he is more senior than Justice Sotomayor, because he was appointed in 2005 or 2006.
Would he stay in his seat, or would he move over here and everybody shift around?
I'm not sure about that, because I'm trying to think, because it would have been Thomas, Ginsburg, Breyer, Alito in terms of seniority. So who knows how they arranged that, but it's clear that seniority matters in terms of how they set that up. And I believe that's part of the tradition when you even get a group photo, is to kind of show a little bit of how the institution even works.
That's cool. And so I thought it would be important like to get that visual, and I'll send you guys the links to where this is all so you can see, match up their names with who they are. And then Amy Coney Barrett is a new justice. She is right here. And then next question, who nominates and confirms the justices? So a little hint, I'll give you a little picture.
Well, Marissa got that right because she got both parts right. So the president does nominate. The Senate has what's known as the power of advice and consent. The text doesn't really say anything else, as we'll kind of explore a little bit more. The Constitution really doesn't say very much at all about the confirmation process, other than the president has the choice to nominate. The Senate has a role in confirming. And by the way, that's for Supreme Court judges. So for those lower courts, as we'll talk about those, it's Congress's choice. Under the Constitution, the president could just be able to appoint members if Congress chose to do so. That's not how Congress deals with other judicial nominees. But that's what the text actually says. This Kerry is showing you. The president shall nominate with advice and consent of the Senate, judges of the Supreme Court. That's it. So all the other rules we end up talking about are ones that have been created over time. But those are what we say were norms or precedents or simply actions of Congress rather than something mandated by the Constitution itself. So
Article 3 is pretty short. Yeah, I was like, that's a pretty short article.
Is we'll get to our little discussion of the framing and the history. You'll see that most of that discussion is not about the text. They just did not spend very much time at all in Philadelphia on the text of Article 3. The real arguments came in the ratification period and thereafter. So as one person has put it, they sort of punted it, right?
Yeah, I like that. There's our sports.
So that Congress could deal with the problem, which they did. So what are the three
third
levels?
Question.
Yep. Yeah, what are the three levels of the system? So Curry's helpfully laid that out for you. We have the Supreme Court, the Court of Appeals, and the district courts. So what this means is district courts are essentially federal trial courts, meaning federal meaning the national system, trial courts meaning the lowest level in that system. So for suits between citizens or suits concerning what we would call a federal question, they start there in the lowest court, right? So they have jurisdiction over most cases. From there, we go to the courts of appeal. That's the middle level. It's only an appellate court. What that means is no cases start there. So when we say original jurisdiction, all we're saying is jurisdiction means the power of the court over a particular case. That's it, right? And original meaning it starts there. Most cases started in the district courts. None of them start in the courts of appeal. Those are just appeals from the district courts. And only a handful of cases originate in the Supreme Court. Those cases are laid out by the Constitution itself. So what is called the original jurisdiction of the Supreme Court, that is in Article 3. We're talking about things like suits between states, suits concerning ambassadors, for instance. So there's a small list of cases that would start in the Supreme Court. But for the most part, they are also an appellate court. The difference from the Court of Appeals is that the Supreme Court can also take appeals from the highest state courts, right? So don't forget that there's state courts as well. How do those get to the Supreme Court? If you get to the state Supreme Court or the highest level in the state system, you can appeal from there depending on the kind of question you have, right? In other words, not every single suit can get to the Supreme Court. We'll explain why that is more as we go through today, but that's really important as a takeaway, right? Not everything can get there. And of course, the justices have a lot of control now over which cases they choose to take and which they don't. And as we'll see, there's a lot of cases that they don't take. So that's the basic 3 levels. And then the final question was,
what are the qualifications?
And the answer is, don't show a visual because there really aren't qualifications.
I don't have one.
There aren't. So the answer there is that Article 3 doesn't say anything about qualifications. It's up to the president. Now, of course, what did the founders envision in terms of what would be expected out of justices? That we can talk about. And we can talk about what kind of qualifications emerged over time. Because for most of you, I think you're going to think, okay, I've heard of the judicial nominations. I've heard something in the news. There's all these questions that get asked. Well, that's an important change as we get to the modern period and we think of the way nominations work today, in which there are sort of an agreed upon list of qualifications that people are generally looking for in a justice. But they don't come from the Constitution. And they don't necessarily come from the acts of Congress either. They're instead what we would call norms.
Got it. So before we get to like some of the Supreme Court or SCOTUS factoids, do you want to look at Article 3, Section 1 a little closer and kind of get the big idea out? And then we'll jump into how do the cases come up from the people to the Supreme Court? What can the Supreme Court hear? And then Ivan with an awesome question. What certiorari, does it come from the Roman? Yeah, thank you. Does it come from the Romans and Latin background? So we'll get into like the word origin as well, which I love questions like that because I always want to know not just what does it mean, but where does the actual word come and what's the history behind the word. So Article 3, Nick, and again, it's not too long. We looked at Section 2 a minute ago about how a Supreme Court justice is chosen and appointed, but Article 1 kind of lays out the courts.
Yeah, I'll note a couple things that are in Section 1 that are worth pulling out because they're important. One is there's a vesting clause. We talked about that with Article 1, Article 2 when we talked about Congress and the presidency, but shall be vested in one Supreme Court. That means the judicial power of the national system, the national government, is in the Supreme Court. And then such inferior courts as Congress may establish. In other words, Congress has the power to create the federal court system. So we just talked about those 3 levels. Those exist because Congress created the Court of Appeals and the district courts as they exist now. Those 94 judicial districts, the way the courts of appeals are split up, the circuits themselves, all that is done by congressional action only. So Congress, in other words, can also change that anytime they want to. So it's really important because you'll see here that Congress actually gets power in Section 1 here. Then it says that judges, both of the Supreme and inferior courts, note that language, it's really important. That means any federal judges hold their offices during good behavior. This is what's called the good behavior standard. What this means, you'll hear this as a lifetime appointment. So Article 3 does not say lifetime appointment. The reason we talk about it is it says during good behavior. That standard is really hard to break. If you go and you look at Article 1 and you look at Congress's power over impeachments, that also includes justices as well as the president. It's also hard to impeach judges. We'll see, we can talk about the single historical example of a Supreme Court justice being impeached. But it's a real hard standard. And that was, as Alexander Hamilton talked about, we can get to, that was on purpose. This was to create what we call judicial independence. And that's that last part of Article 3, Section 1. That looks like a lot of language. It might be confusing. All that's really saying is that the compensation, their pay is guaranteed. Now, why did the founders think that's important? Well, that's another part of judicial independence, right? Is don't let the justices be dependent on Congress for their pay, because if they are, they'll become corrupt, right? This independence is really important. And so both those pieces are components of that independence.
And so you have this like kind of big idea here. So Article 3 sets up the judicial branch, and their job is to interpret the laws. And it's then you layer in judicial independence, lifetime tenure, and the power of judicial review. There's a lot of like kind of big ideas here, but I love this big idea within big ideas. And the rule on the constitutionality of laws, again, that goes back to interpreting the laws and what type of laws do they interpret, and actions taken. I just wanted to like highlight for us all at the end that the rule on constitutionality of laws passed and actions taken by the elected branches. When Nick like spelled this out, I said it's so important to unpack this because when we think about, we think about the president, we think of Congress, we also need to understand that there is a separate branch there and established to also have checks and connections with the other two branches to say, hey, Congress, your law is not right, or to say, hey, President, you can't take that action. And so there is a complementary and a checking mechanism within that third branch. Again, back to that triangle we keep talking about in class. Very powerful structure, but because it has three really strong sides. So do you want to break down anything else in this big idea, or do you want to jump right into some sections?
I would like to jump in, but what I will say, I'll say one thing, which is that we just talked about judicial review for the first time today. Let us note that in the text of Article 3, that does not come up. So it is important to highlight that judicial review and this power of interpreting the laws, that is something we get, as we'll talk about, from the Federalist Papers, from the Marshall Court. It's something that emerges out of experience, and it was an idea that existed, of course, during the writing of the Constitution. It's not in the text, right? It's just a reminder that Article 3 doesn't say very much. So some of the most important ideas about what the Supreme Court does do not come from the text itself.
And that's kind of cool. So like the actions of the courts define who they are. So I think that's kind of fascinating. Now, do you want to walk through how a decision gets to the court, or would you like to jump into that? Okay, good.
Yeah, let's do that quick because it is worth going over. The certiorari, I believe that is a Latin term. I would have to look up to recall what certiorari itself necessarily means. I knew during law school, but it's been a while. I'll be honest. This is a good lesson. Teachers have to look things up too. If they don't admit it, they're just not telling you. We all have to look things up.
With a law degree and a PhD, still have to look things up. So we all have to look things up.
You have to call me doctor, right? So, but we have to look things up too. But the important thing is what the writ itself is, right? And the writ itself is simply, all it refers to is the court giving an order to accept a case, right? What it means is that when a party appeals a lower court decision, they apply for this writ. That writ is just an action by the Supreme Court that says we accept this case. The reason a writ is needed is because that isn't part of their original jurisdiction. Remember, we just talked about that. If it can start at the Supreme Court, no writ is needed. If it's an appeal that they decide to accept as opposed to decline, it's about the writ, right? So they can decline or they can issue this writ. So when we talk about a writ of certiorari, all we're doing is saying these are the cases that the court either chooses to accept or decline to hear, right? That's what the writ is about. If they do, right? So the request for a rehearing by en banc circuit court panel, that's just something that happens at the Court of Appeals. So if you're at that intermediate level, you can apply to have a rehearing, which is basically more justices of that circuit, right? So within a given circuit, that just means the Ninth Circuit, for instance, is pretty much all of California and some other parts of the West, right? Out here, we're in the Third Circuit. That covers a pretty good amount of ground too. There's a lot of judges, federal judges within that circuit who can be called to have a larger panel. That's all that means, right? So it starts from the district court, it goes to a 3-judge circuit court panel, it can be reheard en banc, and then you apply for this writ of certiorari to the Supreme Court. Say the Supreme Court takes it. Do you want to go to that part, Kerry?
Yeah,
the Supreme Court takes it?
Absolutely.
So that, right, so say the Supreme Court takes it. Well, that in of itself is actually important, right? How is it that the Supreme Court makes a decision, right? Because they don't take every case. In fact, as we'll show you the numbers, the vast majority of cases apply to the Supreme Court, which is anywhere between 7,000 to 10,000 per year. Supreme Court takes under 100. That is a very low number, right? So what are they looking for? Generally speaking, we can say they're looking for broad, important national issues, although that's not always the case. Sometimes the issues are pretty technical, frankly. They're about things like bankruptcy. things that most of us, even lawyers, don't really know very much about. So it depends, right? What we say is that the Supreme Court has control over their docket. The docket just means the cases that they are going to take and hear, right? And that includes the ones they have to hear if there are mandatory cases. So the docket is just that term, that year in the Supreme Court, the cases that they are going to hear. That's what we mean. So how does the Supreme Court have that control? Congress gave them that control in 1925. That's important to note. For a very long time, the Supreme Court didn't really control the cases before them. But Chief Justice Taft lobbied to get that control. And ever since then, the last 95 years, the Supreme Court has had control over the cases they hear for the vast majority of them. And they don't hear very many, and that's declined over time. That's an important thing to note. So what happens is the justices of the Supreme Court convene for something called conference. And in conference, they do a couple things. They talk about the cases they hear at oral argument that week. They may talk about opinions they're going to issue, if they are going to issue them. And they're going to talk about cases that they will or won't hear. And they'll hear arguments for all those things. And the arguments are done by seniority, right? So the justices in a normal time, right now they have to be on Zoom, but if typically they would be around a table by seniority, right? And they would speak by seniority, starting with the Chief Justice. Then, as we talked about in the picture, Justice Thomas, Justice Breyer, and so on, right? So if, by the way, if you listen to the oral arguments now, which you can hear all of them, this is exactly what happens, right? The Chief Justice starts, and then we go by seniority, and then justices can ask as many questions as they want to, though typically they try to control themselves and ask 2 to 3 questions. So that's how they do this, right? So they have conference. We have something called the Rule of 4. What that means is 4 justices need to vote to issue this writ of certiorari, right? To grant cert to hear a petition, right? So again, remember, the court doesn't hear very many, right? And then from there, briefs are filed. Briefs, what we mean are written documents that have the best arguments for a particular side, right? We generally say there are 2 sides to the case, right? There's the petitioners, those who are petitioning for the appeal to the Supreme Court, and then the respondent, the other party. They each file briefs before the Supreme Court. They often respond to each other's briefs, and then friends of the court, what are called amicus briefs, are filed. All different people file these things, organizations, professors, famous people, members of Congress. You see all different kinds of these things. So basically, the Supreme Court is going to hear, in a really important case, they're going to have tons of these briefs, trying to give them all the information and arguments for different positions. And then, as I noted, in the conferences, when they'll discuss the arguments in the cases they hear. Generally, they'll give votes. The reason they give votes is they have to decide who will write the opinion. Deciding a majority opinion, that is the opinion that controls, that has the most votes, that's also done by seniority. So if the Chief Justice is in the majority, then he picks who writes it. He can pick himself anytime he wants to. If not, then the most senior justice in the majority picks who writes that majority opinion.
So 2 really kind of cool factoids, I think, for students when they're talking about teamwork like this.
Yes.
As we talked to Justice Breyer, and Justice Breyer says one of the things that they do, not only do they follow these like historical rules, but they also follow general rules like you never speak once unless everybody's gotten a chance. So they have these norms that are set up to promote civil dialogue. And then the other kind of really fascinating factoid is when it was Sandra Day O'Connor, they were on the writing opinion side and writing it. She gave it to Ruth Bader Ginsburg. Even though she was senior, she allowed her to do it because she passed and said, you do it. because she was giving another justice an opportunity to step forward and write it. And that was one of the first pieces that she ever wrote as a leading opinion. And it's just fascinating to look at. They're doing all this legal work, but they're also kind of walking through together and following norms and being good team players together to work together to make sure that they're like just a great example for our country.
Yeah, it's the collegiality of the court. I think that's always an important thing, is that the justices will always talk about. This is why partisanship doesn't just explain what the court does, right?
Exactly, and that's great. Good, because a lot of people say, "Oh, but the president or this president picked them, so they're gonna, in the court case, they're gonna vote this way." And this is not what we see with our courts, and that's why they put into Article 3 that there was a separation of the justices, that they were almost, again, in a bubble, saying that they look at the law and they decide by the law and they have judicial independence. Now,
Right.
Nick, we have 4 minutes left to class and we have a ton to go on. Do you want to jump into Marbury versus Madison and judicial review and kind of go through some of those modern cases real quick, or not modern, but not 1787 time period?
I mean, we can fast forward. I mean, we should start by saying that judicial review itself, as I mentioned at the beginning, doesn't come out of nowhere. So at the Constitutional Convention, really at the ratifying conventions, it's in the air. It's in the air because several state Supreme Courts had already dealt with this. Alexander Hamilton himself is a lawyer in a, you don't need to know a case. It's before the New York court. He was in New York, so his case has come out of New York. But he argued for this power of reviewing for constitutionality under the state constitution, yes, but for this power of review. And you saw this in Pennsylvania, Rhode Island, other places. John Marshall himself in the Virginia ratifying convention talked about judicial review as an important check and power that the Supreme Court would have to hold. So before even the court itself is assembled, this is an understood power. It's understood from English courts, from, you don't need to know Blackstone. It's a legal reference. But the point is, these ideas are out there. And the Supreme Court immediately in the 1790s, even before Marbury versus Madison, is starting to use its power of review. It reviews and strikes down some state laws. I won't go over the particular cases because you don't need to know these things. But the point is that you start to see it even before Marshall himself formulates what we know of as this claim of judicial review. So all that's to say is Marshall isn't taking this from nowhere. Why Marbury versus Madison is important isn't because he creates judicial review. It is because it articulates judicial review in such a clear and concise way, right? That's why it's powerful, right? So I'm just hoping that for the students, you understand this difference, right?
I think that's really helpful because we do this thing when we're teaching history where we have like somebody's like this great epiphany moment and boom, a light bulb goes off and it changes the world. And in reality, it's not like that, guys. That's not real history.
Right.
Real history is it was a lot of ideas bubbling up, and then the next person took the baton and pushed it farther forward or backwards or sideways. But I think that's a great thing to remember. What was that?
Well, and Hamilton's very important here. I mean, in Marbury, Marshall's clearly referencing Hamilton in Federalist 78, in which Hamilton most clearly articulated his idea of what the court's duty was. And Hamilton's notion was, look, the court is the weakest branch, but it has this really important power, that power of review, in order to balance the system and ensure that no actions of the other two branches exceed their constitutional boundaries, right? That's the duty of the court. Well, Marshall expounds upon that, right? So the idea is he extends it, he talks about it more. How the case gets to the Supreme Court, maybe the most important thing about it probably is that we've already talked about the election of 1800. We love to talk about it. And without talking about the election, there's all these midnight appointments. It's a lame duck administration. The Adams administration and the Federalists, they create new circuit courts. We just talked about Congress having this power over the court system. Well, they create all these new positions, and then they try to fill as many of them as possible. One of these gentlemen is Mr. Marbury. The reason he doesn't get his commission, he doesn't get his appointment, well, John Marshall has two jobs. He's Secretary of State and Chief Justice. He doesn't sign all the papers in enough time. So James Madison shows up on day one, and there's a stack of papers. It's either in the desk or on top of the desk. And Thomas Jefferson, the new president, says, Madison, don't issue those. Hold on to those, because the new party in charge, they want to refashion the court system, and they are going to do that with their own Judiciary Act. You don't need that, know that particular history. The point is, it's a contentious political moment. And in the middle of this, all these actors are doing these things. And these are papers that are lost and not issued. It's kind of normal human drama. Mr. Marbury is a man who knows people. He files a suit. Charles Lee, who's a rather notable judicial figure at the time, argues the case for him before the Supreme Court. Why doesn't the Supreme Court hear it for 2 years? Well, Jefferson's allies in Congress passed Judiciary Act of 1802. Not only do they get rid of those new Federalist appointments, in other words, they kick judges out of their lifetime appointments. The Supreme Court won't meet for another year. They hold off their term. So it doesn't come out until 1803. What's important about it? Basically, the summary is simple, right? Three things happen in Marbury versus Madison. What Marshall says is, look, Mr. Marbury, he deserves his commission. He should be granted his commission. Those are the two things, right? Yes, he has a right to his commission. Yes, he was given this commission. But there's a third question. Does the court have power to give him this commission? In other words, to grant a writ. We don't have to go into that writ. You don't need to know a writ of mandamus. You just need to know that what Marshall said is no. Congress could not have given the power to the Supreme Court to issue this, to give him what we would call a remedy, which just means what action the court takes to make a person more whole, right? To give them what they want. Marshall says the court can't do that because Congress acted unconstitutionally in granting this power to the Supreme Court. So you see what happened here, right? This is, historians always talking about this as being clever, because what Marshall says is, yes, Mr. Marbury is right, but no, the court can't do that because Congress did something unconstitutional. Who gets to say what is unconstitutional? We do. Why? Look at Article 3. Look at what Hamilton said. The duty of the courts is to review. And so this is as I say, an articulation of the exceptional duty of the Supreme Court to go through judicial review, right? And so that is why Marbury is so important. We can talk for a minute about the aftermath because it's kind of worth highlighting all that. But go ahead, Kerry. I feel like yeah,
because we do have to wrap up, but Iman has a great point. So does that mean Madison won? And I was like, well, in a way, I guess it means Jefferson and Madison won.
Yes.
But the reality of it is the courts won. That's at the end of this. This is what you get. So like the story is so soap opera-y, like there's like all this stuff going on. But at the end of the day, what this does is it puts into the Supreme Court clearly in this case that the court's job is to look at acts and laws and say if they're unconstitutional or not. And that's what this really does. That's the huge takeaway, not who wins and what happens to those guys, but really the fact that it takes, you know, the Federalist paper and applies it to the courts and then puts it into the docket and through the opinion. And that is a game changer for the courts and really pushes it out there as a more broader lead. So that's kind of the fascinating thing. So Marbury lost, even though Marshall was a Federalist. Thank you, Iman. Like, that is the best statement, because we need to wrap up class with the idea of judicial independence. And so even though Marshall could have been a Federalist, he was looking at the law and saying, doing his job and saying, was that act by Congress to do that in the first place, was it constitutional? So Nick, pull us all together, wrap us up with the idea of judicial independence, and send us away. You have 1 minute. You can do it.
I will try, but I think we should say just 1 second about what happens after, because what Aman said is actually important, and it's important in the sense that this is why historians talk so much about Marbury still, is precisely because Marshall's kind of getting both things. Jefferson kind of wins, Marshall kind of wins. Jefferson knows he doesn't really win. He's mad about this decision. He's mad because Jefferson believes that every department, every branch should review themselves for whether or not an action is constitutional. So what he opposes is what he calls judicial supremacy, the idea that the Supreme Court has the final word on whether or not something is constitutional. And it's really important to just talk about this because it's what follows Marbury versus Madison, and we still have this debate, is whether or not the court should specifically have the final say, right? Judicial supremacy as opposed to review. So Jefferson didn't say, no, the court shouldn't be able to review acts necessarily, although he thought they shouldn't as often. His problem was the idea that the court was the final word. He thought that the president and Congress also had a duty. And this is something you see articulated by those who follow him. Even Andrew Jackson during the 1830s. We didn't get to talk about the Native American cases, but those are always great to get in for that reason. So that it's important because, yes, it articulates this vision. There's so many Marshall Court cases that kind of expand the powers. Jefferson and his followers are mad because they see what happens afterwards, where the court says we can review state courts, state laws, all things like this. And the Native American cases are whether or not they can even deal with actions regarding a potentially sovereign nation. So how far does judicial power stretch? That's going to be a key issue going forward, and Marbury does not end that discussion. But judicial independence, even though there are going to be people who say they're not comfortable with it, largely that's a cornerstone of the system, right? The sense that, as Kerry noted at the very beginning, one of the reasons why the court can have this collegiality, this ability to have norms of working together, of trying to find consensus. We didn't even show you the statistics where there are typically 6 or 7 different lineups and even 5 to 4 decisions, right? Justices are all over the map. They disagree with each other all the time. There isn't 2 teams. How does that happen? That's partly a result of independence, right? Because once they're on the court, the president can't say, oh, I screwed up. I don't want that justice on there anymore. I want to take him out. No, good behavior. I said there's only one justice who's been removed, and that was Samuel Chase. He was impeached, but he wasn't removed in 1804 by Jefferson. The same guy tried to get rid of a member of the Supreme Court who was a Federalist, who had spoken out politically against the actions of Jefferson and his allies. And it didn't work, and it was never really tried again, because independence has been this cornerstone of our system, right? So you can look through a lot of justices who have gone against the wishes of those who appointed them. And there's nothing the president can do about it.
Awesome.
So independence is...
And it's important because then there's no way for the branch to be able to truly check if they're not in a way safeguarded by judicial independence. So thank you so much.
That's exactly what Hamilton said. We'll leave with that, right? That's what Hamilton said.
There we are. That's what Hamilton said. I don't always agree with Hamilton, but here's where I do. So it was a 40-minute class, even though it's supposed to be 30, guys. But thank you for hanging in there with us. We're teaching all week. It's going to be a great week. And this is such an interesting part of the Constitution we don't talk about enough. So thanks so much. If you're joining us again, feel free to email me any of your questions, and we'll fill them in as we go through the week. Thank you, Nick. That flew.
Yes.
I'm going to now stop the